In a work comp setting, the insurance company or the employer has the right to direct care. What that means is they have the right to initially choose the doctor that treats the injured worker. The doctor is responsible for providing timely and competent medical care. Oftentimes, these doctors are loyal to the insurance company and loyal to the employer and do not provide care that's adequate for the injured worker. There is an avenue in Iowa law that allows an injured worker to seek alternate medical care when their medical care isn't provided adequately. We have had in the last couple years an abundance of cases where we have been forced on behalf of our clients to apply for medical care, alternate medical care. In one particular case, we had a situation where a doctor was both not returning phone calls, wasn't examining and seeing the patient, and was not providing adequate medical care. We brought an action on behalf of our client, which was reviewed by a deputy workers' compensation commissioner. I'd like to read you part of what the commissioner wrote, which I think adequately states the law as it applies to alternate medical care. First of all, Iowa Code Section 85.24 sub 4 provides in part, for purposes of this section, the employer is obligated to furnish reasonable services and supplies to treat an injured employee and has the right to choose the care. The treatment must be offered promptly and be reasonably suited to treat the injury without undue convenience to the employee. If the employee has reason to be dissatisfied with the care offered, the employee should communicate the basis of such dissatisfaction to the employer in writing if requested, following which the employer and the employee may agree to alternate care reasonably suited to treat the injury. If the employer and employee cannot agree on such alternate care, the commissioner may, upon application and reasonable proof of the necessity thereof, allow and order other care. Now, what does that mean? What that means is that the care that is offered has to be reasonable. It has to be reasonable both in proximity and contemplated to treat the injury that the employee is suffering from. If it is not adequate, if it is not timely, and it is not somewhere that is proximately located to the employee, that care is unreasonable. Now, the court went on in this particular case to state an application for alternate medical care is not automatically sustained because the claimant is dissatisfied with the care he has been receiving. Mere dissatisfaction with the medical care is not ample grounds for granting an application for alternate medical care. Rather, the claimant, or the injured worker in this case, must show that the care was not offered promptly and was not reasonably suited to treat the injury, or that the care was unduly inconvenient for the claimant. These are questions of fact, which means that these are questions of credibility that the employee has the right to bring to the deputy commissioner's attention. If the care offered is not reasonably suited to treat the injury and it's not convenient for the employee, the court may order alternate medical care, which means that at that time the employee gets to choose his or her own doctor. This is very significant because in cases where alternate medical care is ordered and the employee gets to choose their medical care, they get to select the provider. And when they get to select the provider, the treater is normally more loyal to the patient. Now, in typical cases, you will hear the defense attorney or the insurance company refer to the directed care physician that the insurance company chooses as your doctor. They are not your doctor. They are a treating doctor for you. In an alternate medical care situation, when you get to pick your doctor, they are your doctor. The difference is loyalty. You will find that doctors that are selected by the insurance company oftentimes minimize your injury or minimize the injured worker's injury and oftentimes treat minimally what they need to do instead of treating what your own doctor would do for you. The problem is that your own doctor will not treat you if there's a workers' compensation claim pending, unless the judge allows the injured worker to select their doctor through alternate medical care. If you have a question about this or any other question, feel free to contact Lipman Law Firm and contact me personally at 515-276-3411.